Planning phase and design phase risk management is the topic of our discussion today. And as you all know, this is the meat of the services that you provide to your clients. You have the most control over this phase. This is what your clients are paying you to provide. And it is important that you be able to do this effectively and in a manner that allows you to make a profit on the services that you're providing so that you can continue to stay in business. By necessity, of course, the amount of information we can provide on this phase is somewhat limited. We'll be talking about general thoughts, general procedures. The meat of this part will obviously depend on the nature of your practice, the nature of your clients, but I think we can still provide you with some meaningful guidance on how to go about to manage the risk during the planning phase and the design phase of your services. So really, this process begins with the development of a clear, coherent definition of the project, along with a clear, coherent plan for performing the scope of services provided for in the owner-design professional agreement. So at this point, you have, in all likelihood, negotiated an agreement with the client. You said you're going to provide these services to the client. The client has said, we're going to pay you based on your agreement. So how do you go about performing your services? What do you need to do to make this work? Well, obviously, it depends on what it is that you're providing, but remember that generally your role as a design professional is to help the client put a capital asset in place. Of course, that is big picture, and it depends on what kind of client, what kind of project it is. But generally speaking, your role is to help them put that capital asset in place. So you need to help the client better define what it is that they hope to achieve. When we talk about the different phases of planning, design phase, and so on, what we're talking about essentially is taken from the EJCDC documents and the AIA contract documents. If you're not familiar with these documents, I urge you to become familiar with them. Even if you're not working with them regularly, they do provide you with a clear breakdown of the different phases that you all offer to your clients. And even if you're reviewing a client drafted contract, it really does help to know what the industry in your respective professions think about providing planning and design phases, how to break it down, what the scheduled deliverables are, and so on. We'll talk about some of that today, but really the resources that we're going off of are in the standard form documents that you should know. So today we'll talk about how to plan the project. You will be defining the project for the client, and we'll talk about all of these different elements. And then the next phase, we'll talk about how to staff the project and developing a project work plan. Again, this is an important risk management step that you should take. And not only does it help you manage the process, but we think in the event of a claim, knowing what you did, how you thought about the project, how you broke down the tasks, really does help identify the care that you took in planning the project and showing that indeed you did everything that you could to manage the project reasonably and in a manner that makes sense. So not only is it important that you staff and the project and develop a work breakdown structure, as we'll talk about, but it's also important that in the event of a claim that you can actually show how you planned for the project and show that you took all reasonable steps. And then finally, we will talk about how to perform planning and design services. And in this phase, we'll talk about how the EJCDC and AIA documents break down your services that you're providing to your client. So let's talk about planning the project. How do you go about defining the project and making sure that the owner's expectations are actually well defined in a document? This is important because from what we see in our claims database is that most claims actually come from your clients. And it is often disappointed owners who are often the cause of liability for design professionals. About 2/3 to 70% of all claims against design professionals come from your owners, from the clients. And so it's important that you and the owners sit down and agree on what the parameters of the project are. Remember that for the client, for the owner, this project oftentimes represents a very significant outlay of resources on their part. And they're relying on you, the design professional, to help put that capital asset into place. So to that end, you need to guide them through the process about what is reasonable and what can be expected. And really, they're relying on you to help them accomplish that. The owner, as you know, may well have very different constituencies beyond your client contact. They may report to a board. They may report to other people in their organization. So being able to define that program so that everybody is on the same page is really essential. So you need to be able to articulate what their standards and project goals are so that you and the owner can benefit from the relationship, so that you can provide reasonable services for which you've been paid your fee, and they are happy with the services that you've provided. So to define that project, you need to think about, okay, what is the owner's program, schedule, and budget? What's their strategy for procuring construction services? And we'll talk about that. What is the available information on existing conditions? Have you worked in that area before? Do you know what to expect as far as existing conditions? And so on. What are the applicable laws and regulations that apply to the project? Oftentimes, you are assisting the owner in getting a permit from the authority having jurisdiction. So it could be the county, it could be the city, or whatever the case may be. So you need to know what the applicable laws and regulations are and what the processes are in helping the owner secure that permit. What are the owner's design criteria and standards? Oftentimes, owners have their own particular requirements about their facilities. And it oftentimes goes beyond what the code requires. And you need to be aware of that so that you can incorporate their wishes into the project. What are the quality program requirements that the client needs and that you need to make sure that the deliverables that you're providing have met certain standards that you can be proud of, and that the documents themselves have been checked. And then finally, you should, at least for significant projects, think about developing a project summary report that summarizes all of the information that you've gathered on behalf of the owner, so that both you and the client are working off of the same set of understandings. Oftentimes what happens is that as you gather information, the owner is still working on information that is old or based on the assumptions that they had about the project. You have updated information. And if that information is not conveyed back to the owner, you are starting out with a mismatch between what you are thinking and what the owner is thinking. So you need to make sure that after all of this planning that you've done, after all the research, that it's prudent, to the way we see it, to prepare a project summary report on which you can base your planning activities and scope breakdown activities as well. So the owner's program, schedule, and budget. This is indeed where the rubber, so to speak, hits the road. The owner has certain objectives. They want to put a certain facility in place, and that, of course, is their wish list. They may also have schedule constraints. They may have to open the facility by a certain time. It could be a court mandated decree that they need to meet. Whatever the case may be, there's usually is a schedule component to the owner's program. They may well have performance requirements that they need to meet. If it's a water treatment plant, obviously they need to be aware of what the clean water standards are, and so on. So that is indeed part of the owner's program. Your job as a design professional is to balance their program aspirations against budget and schedule realities once your services start. So it's important that you be able to, the owner be able to articulate what it is that they want, but at the same time, they need to be able to relate that back to reality, to what the practical limitations are. The owner's construction budget often sets a fixed construction cost limit that you need to be aware of. And depending on how your agreement is structured, that could very well be an obligation on your part to try to design to that. And you need to be aware of what your obligations are in that regard. If the owner does not have contingencies because construction is not set, that could be a warning sign to you that the owner may not have enough resources available for that. Of course, at the same time, you need to be aware of where the money is coming from, especially for the construction cost, which is, again, often a significant outlay. So if they're borrowing the money, what are the lender's requirements? What is expected of the owner before they can secure the loan? How do your services play into that? Does the owner, does the lender have requirements about what should be in this set of services? All of these need to be identified early on, and you and the owner need to come to an agreement on what is reasonable. When it comes to cost, you should really advise the owner that your services, when it comes to construction costs, are often characterized as an opinion of probable construction costs. You're not in the business, generally speaking, of providing detailed cost estimates. You don't know what the current construction costs are, what labor costs, what the challenges that the contractors are facing, but you can provide them with an estimate based on your previous experience and also based on conceptual cost data that you may have. So you may know that laying concrete pipe of a certain size may cost so many dollars per lineal feet. You may be able indeed to provide them with that kind of guidance, but beyond that, ultimately, oftentimes design firms are not in a position to provide the owner with an assurance. If the issue is important, and it often is to the client, you should guide the owner to engage a cost consultant directly, or you can do that as part of the services and make sure that you're engaging somebody who can provide that type of service to the client. Remember that obviously the ability to control cost decreases as your design progresses. So, for all intents and purposes, really the most effective time to have a cost consultant is early in the design process before the requirements are baked in. So that is an area that really needs to be thought about because, again, cost is very important for the client, one of the biggest pain points that they have. And oftentimes, as you know, construction itself is a fairly uncertain business. And the notion that the owner should have contingencies in place should also be communicated to the owner, especially if it's a large and complex project. The other issue that needs to be addressed in your planning services is you're planning the project, helping the owner define the project is what is their strategy for procuring construction services? Um, for the purposes of this discussion, we're assuming that the project is in a design, award, build model, meaning that you provide the design / consulting services, provide the owner with a set of construction documents with which they use to award a separate construction contract to the contractor. But even within that model, there are several ways that the owner may decide to proceed. They can use multiple prime contractors rather than one prime or general contractor. This could mean that you have to break up the packages, the deliverables, into different setups so that the owner can better define what the contract documents are with the different contractors. The owner may well decide to use fast-track construction where individual phases may overlap. So if, for example, they know that they can get started on excavation and putting in the foundation fairly quickly, and you know that you can get the permit for that quickly, you may well decide to go ahead and submit that package for permitting and get started on that piece while the design for the superstructure is continuing on. Or there may be utility relocation required on site that could start before the rest of the project is started or permitted. So this could well be something that the owner may decide to do, and that is the earlier that the owner can identify what their strategy is, the better off you are. They may decide to directly purchase major equipment or components that they know that they're going to use. It's not unusual, for example, for a wastewater treatment plant operator to go ahead and get the equipment directly from the providers. The owner may have experience with particular equipment models, and therefore does not want to go through that procurement process through the contractor. All of these alternatives may provide cost, schedule, or other benefits to the owner, but there's also an increase in risk to the owner. They are proceeding to get those benefits, those cost, schedule advantages, but it could well be that due to the expedited nature of the construction process, that there's increased risk due to, for example, lack of coordination or something else that has not been picked up when you're doing these types of arrangements. So to that end, it behooves you to help the owner identify what their strategy is and advise them on what the pros and cons are about that strategy. Of course, in practical terms, depending on their decisions, this will affect your services and deliverables, right? And that is really what we're driving at here. You need to be aware of what the owner's strategy is so that you can meet their needs and their requirements accordingly. You don't want to be the last to know that they intend to break up the construction contract into different packages. If they are using third-party professionals like construction or program managers, you need to know that and make sure that your services are coordinated with the services that the construction manager is providing. This is not that unusual an arrangement these days, but again, your services and what you're providing to the owner need to identify any known third parties that will be working on the owner's behalf to put this construction into place. And what does that mean in reality? The reality is that you have to go ahead and amend the professional service agreement if they're engaging construction or program managers, but because it does impact who you're dealing with. You need to know what the construction manager's authority level is, what they're actually doing, and so on. Obviously, if you're working in a public arena with a public agency, they don't have as much discretion, generally speaking, about how to go about with the construction process. They're oftentimes required to put these projects out to bid. So you may not have all of these variances in how the construction services are being procured, because it may well be governed by state statute. So, but you still need to be able to identify what the potential variances could be, and help the owner identify what their options are. The other thing that needs to happen during a planning phase is the identification of information on existing conditions. This is essential for you to be able to provide design services based on the information that's available to you. If it's not under your design, under your contract, then you probably need to rely on information provided by surveyors, by geotechnical engineers, environmental assessments, and others who form the core of really the pre-project assessment team. And what you want to think about when you're doing this is, A, getting the client to identify what information there is on existing conditions, how recent is it, how reliable is it, and B, if the owner is providing you with this information, you want to make sure that you have the right to rely on the existing condition that is being provided to you. That the owner affirmatively says, indeed, you have the right to rely on this information. If the owner is not willing to give you the right to rely on the information, then essentially these services, this information, the services that leads to the information will have to be replicated. If the owner is not willing to stand behind it, or if the information is no longer reliable, then that needs to be addressed. And oftentimes that is addressed by putting it in your contract or having the owner engage the services of others. But this needs to be fleshed out clearly so that you know exactly what it is that you're dealing with. So here are some examples of information that is used to support the design process. Data relative to previous designs or investigations or adjacent to the site. It's not unusual for the owner to have started the process of designing something for a particular site earlier and gone through developing information, or it could be the previous owner for a particular site that has engaged these surveys and geotechnical investigations. If that is indeed still reliable, you may be able to rely on that. Project description, zoning, deed, and other land use restrictions. This is oftentimes available in the survey and provides you with information about what is available and what is possible on this project, what the site can be developed for, if there are any restrictions. Again, that can help inform you about what the site can be used for. If there is a variance process and that the client or the owner is going through an entitlement process with the county or the city to be able to change the use, be aware that although you may have practical information about how that process is going to work, that is essentially a legal process, and the owner will have to rely on their legal advisors to get that done. What I have seen oftentimes is that, civil site engineers especially know a heck of a lot about the entitlement process and know what is possible to get approved. But really, if the owner is seeking a variance, you can certainly assist them in developing those plans. But ultimately, the determination is a legal process, and the owner should rely on their own attorneys to get that done. Property boundary, easement, right-of-way information, all of that is important information that should be identified. Obviously, subsurface conditions, things that you know about on the site or the adjacent site, what has happened before, all of that should be gathered and compiled, and make sure that that has been incorporated into your thinking process as you think about what the project itself is going to look like. Environmental assessments, audits, investigations, and impact statements. Again, depending on the site, this could be very important about what the client can do with that site and what they're entitled to do or what special steps they need to take. As a design professional providing services to your client, if you're helping them plan the project, this is important that you address all of the various factors that could impact the project as you provide services. The next major area that needs to be thought about are the applicable laws and regulations. And this, in this day and age, obviously, there's a lot of information that is available online. However, there are there's often a need to go in and actually discuss the project with local officials, because even though the laws and regulations may be available online and may be readily available, how those are interpreted and how those are actually implemented are oftentimes it's not readily available online. So anytime that you need to flesh things out and how to get things done in a particular county, especially if you haven't worked there before, it's important, I think, to go in and establish relationships with the folks who are actually reviewing the plans when you're helping the client pull the permits. When you do the research, it has to be done in a systematic manner so that you're addressing each known functional area that needs to be addressed and that needs to be identified and addressed. If you do this in a systematic and well-documented approach, then at least, if there's a dispute with the client, you can show what steps you took to identify what the pertinent laws and regulations are, and what the nature of your services was, so that you can show that you did diligently try to identify all the pertinent laws and regulations. As a design professional, helping the owner pull a permit, you should be generally familiar with the applicable laws and regulations. That is what allows you to provide specialized services. So it is on you really to try and figure this out as much as possible. So anytime that you are helping the owner define the project, it's important that you help them identify things that apply to their project, such as general building codes, plumbing, electrical, energy conservation codes, state laws, local zoning ordinances, local county and state agencies and commissions and federal agencies. Obviously, it's not always clear-cut. There are certain areas that are addressed, both at the state law or the local law, and there may be any number of different agencies that will look at the same set of plans and provide you feedback. It's not always clear-cut how things are going to be interpreted, especially between different agencies that are going to be reviewing these. So you need to be current on what's going on and how things have been interpreted, and advise the owner as best as you can about what is realistic to expect as far as getting pulling the permit from the county. The owner, of course, may have their own design criteria and standards, especially if they're operating a large facility or a campus. They may have their own minimum requirements that may well go beyond what the county requires. For example, oftentimes if you are tearing down a bunch of trees, there may be a tree replacement plan that you may need to be aware of as far as the county is concerned. Some owners may have a much more aggressive tree conservation plan than what the county requires, just because of the nature of their facility. So a school or a university, for example, may be very concerned about how their development is going to be perceived in a particular neighborhood. So they may well go beyond what is required by the county. You need to know that. Not all of your clients will be interested in what the minimum allowable thresholds are as far as the county codes are required. The owner may well have higher standards. They may require 5-foot sidewalk instead of the mandated 3 or 4-foot sidewalk that the county may have, and so on. You and the owner need to be able to identify these and put this in your project planning document, so that when you're actually doing the design solution, you know what they are and you've come to an agreement. You don't want to be in the midst of a design submittal later on to find out indeed that the owner has different requirements, because that is something that will require that you revise your design solution to accommodate the owner's needs. So insist on identifying what the owner's design criteria are, and make sure that your project managers indeed know what it is and are planning on it accordingly. Quality program requirements essentially mean that you, generally speaking, need to have standard written procedures on how you're going to implement your quality program on every project. For the most part, this is going to be a general document that you, depending on your firm and your firm profile, will say, okay, for all of our projects, when we're doing these types of services, these are the things that are important that need to be addressed as far as our quality program. And then on a case-by-case basis, you may well choose to supplement your basic quality program requirements based on the particular project. But whatever the case may be, this does impact the scope of your services, and you need to think proactively about what the quality program requirements are. Of course, owners often do want proof of a documented quality program. Oftentimes it's part of the request for proposal. So you need to be able to say, indeed, this is our quality program. This is what we did to implement it on your particular project. So if this is an owner requirement, it goes without saying that it does need to be part of the of your services as well. But I think generally, between you and the owner, you need to identify what the quality program is, and act to make sure that you have indeed met those requirements. This assures the owner that you're taking particular care with their project. Again, for the owner, this is a significant outlay. They want to feel comfortable that you, as a design professional, are doing all that you can to meet their program requirements. If you want to do independent peer reviews, it should, we think this is a great risk management tool, obviously, but it should be done by qualified and trained reviewers who know what they're doing. It should encompass a clearly defined scope of review. For it to be most meaningful, it should be done both at the conceptual schematic phase and the final design or report phase, so that there's clear evidence that indeed this was looked at a time when meaningful feedback could have been incorporated from your peers, and that this final solution is also reviewed. And of course, you need to document your comments, responses, and resolutions of any peer review comment that you've received. This is really on you to make sure that any peer review that you implement is actually followed through and addressed in your design solution. Constructability reviews, important element that can be addressed in the planning phase. You're trying to incorporate construction knowledge and experience into the planning and design of the project. This is meaningful feedback. Oftentimes the client, especially in the private sector, may well know who the contractor is going to be, and are not waiting for you to complete the services to engage who the contractor is going to be. And if that's the case, you may well decide to get input from the contractor that will provide you with meaningful feedback. If this is indeed addressed, this is a great way to get you and the owner to agree on what this is going to look like, what the planning process is going to look like, and again, it helps assure you and the client that you have actually thought about how this thing is going to be built. Even if you don't have early input, I think it's important to be able to get feedback at any time, really, even if you don't get it early on in the design phase. A review of the construction documents for clarity, completeness, and ease of construction will still provide you with meaningful feedback, and the client with benefits and significant value. Obviously, if you're in an environment where the whole notion of your construction documents is going out for the lowest bidder or the lowest responsible bidder, this is at odds with constructability review. So if you're in that type of environment, this may not be a practical element of your planning process. And finally, a project summary report. This is really what ideally in the perfect world that you want to be leading towards. After you've done all of this planning with the client, that you be able to point to a particular report that can be used to document your planning assumptions and decisions. It facilitates communication among project stakeholders, and it provides you with a baseline for project control so that you and the client agree on what it is that the project requires, what you identified as the requirements of the owner, and then you can proceed accordingly. If you're dealing with a type of owner, for example, who has to report to others, to boards or committees, then this type of report helps put all of those different minds who may have their own thoughts about what the project should entail. It at least helps, it puts a certain document in the hands of everybody that everybody can review on, and then hopefully from that point on, it's agreed what the project summary is. Especially when you're dealing with entities like churches, nonprofits, where it's not clear who the decision-making processor is, or if it's diffuse in nature. This is really a great tool to be able to convey to people exactly what the project is, so that you have a baseline from which you can discuss any changes once the design process begins. So the summary report should have your program, obviously, the schedule, any milestone dates that you've agreed to that are within your control, that are the targets, the owner's construction budget, and any contingencies that they may have budgeted for that, an opinion of probable construction costs that you've provided based on the program description that obviously will be refined further when you do the design services, the owner's strategy for procuring construction services, owner furnished site data and information, or what the status is on that. Is the site served by public sewer, water, electricity, all of that, all of the utility information, all of that really needs to be put in this project summary report. Any additional information that has been requested by you that you feel like you need during the design phase. Of course, the owner's design criteria and standards, that needs to be clearly stated. The codes and regulations that have been identified that apply to the project, and of course the permitting requirements that govern this particular project. So if you can get that done and you have a project summary report, that is an excellent way to help manage the risk and provide you with a meaningful baseline as you go forward into the design phase. So next step, again, we're talking, in fairly general terms, because we are not design professionals. We don't, all of this will be dependent on the type of project that you offer, the type of clients that you serve, and the size of the project, obviously. But you, at some point, need to know that you're going to staff the project. It could be for smaller firms. You could be the one who's doing everything. Or for larger firms, you need to decide who the personnel are that are going to work on this project. You need to determine availability and experience of your design professionals and the support staff. Make sure that management has oversight appropriate to the project and relative experience of the design team. Who's going to be responsible for communicating with the client and managing the client's needs? The project manager obviously will be, but again, beyond the project management, what kind of oversight are senior principals going to have over the project itself? This needs to be done by you in order to manage the next phase, the design phase, realistically, so that you know exactly what's going on and can address the issues. Are you going to miss a milestone that you've agreed to because you don't have significant resources attached to it? What is going on with your project? But when you're planning it, you need to know what the available staffing is and what the experience level is, and make sure that there's enough resources allocated to making sure that you meet your contractual obligation. If you are engaging consultants, you need to be able to evaluate the major aspects of that team. Their availability and experience, obviously. You need to be able to say, okay, these guys are still financially solvent. They can carry payrolls, cover expenses, and if they're a viable business, that often is not a problem, especially in this climate where there's plenty of work. But you should also look at their ability to satisfy specific contractual requirements, such as insurance coverage. You want to make sure that they do have the ability to stand behind their work and are purchasing the required insurance coverages and can stand behind their work as needed. So the terms of your prime professional consultant agreement should be coordinated with those of the client prime professional agreement. You do not want to give your sub better terms than what you have with the owner. The benefit of using standard form documents like the EJCDC and AIA documents is that all of these issues are integrated and coordinated fairly well. So if you're using the AIA documents, for example, you can use the B101 as your owner prime, as the owner architect agreement, and the C401 for these architect subconsultant agreements, and so on. But if you're not using standard form documents, these are the things that you need to think about how are the quality program requirements and responsibilities being passed on to your subs? What are the design criteria and standards that apply to the sub-consultants? Schedule requirements, the budget requirements, the terms and timing of payment. Cash flow management is an essential part of handling this relationship so that both parties are on the same page. Use and ownership of documents, terms and provisions for termination of services, dispute resolution procedures, and of course your professional liability and other insurance requirements. What is reasonable for your subs, and what kind of limits can they carry, and so on. Obviously, generally speaking, for a prime, you do not want to give a limitation of liability to your subs unless you have such a similar limitation on your services, because that puts the onus on you. Oftentimes, from a risk management standpoint, if the sub-consultant really does want to limit their liability, the arrangement can be made to have that sub directly contract with the owner instead of through you, and then have the owner assume the risk that if their services don't meet the requirements, that the limitation of liability applies to the owner, and that's the risk that the owner takes. So those are some of the issues that would need to be addressed in your sub-consulting agreements. So for a firm, again, fairly general terms, you need to think about your project as how do I break this down into meaningful phases? And there's a well-known project management structure, the work breakdown structure, that will serve as your project foundation of your project work plan. It's a hierarchical representation of your entire scope of services, and the idea is that you're breaking this up into building blocks that are commonly known as work packages. And typically, each work package has an identified deliverable at the end of it, so that you can plan resources accordingly. So you want to be able to define and communicate the design professional scope of services as a task schedule. You want to assign it to a particular resource or a person, schedule it and budget each task, and make sure that the individuals are indeed integrated so that there's coordination between the members of the design team to get this thing done. So the project manager will then create a draft project work plan and a summary level work breakdown structure, and then and the team members will review that and assume responsibility for the different work packages and refine it, and then resolve any conflicts before they finalize the project work plan. That is how, in an ideal world, this is supposed to work. And it does, for the most part, work, especially for larger projects. You need to be able to identify what your work breakdown structure looks like and make sure that the coordination pieces are worked out. So the last phase that we're going to talk about are actually performing planning and design services. Again, to this section, I'm really relying on the description as presented in the EJCDC or AIA documents. And generally speaking, if you take nothing else away from this piece, just realize that if you have particular phases, it's generally understood that you need to complete and have the owner accept each phase before you go on to the next one. And what we don't want to have is a structure where you're required to have the owner sign off and review and sign off, and you don't actually do it. And so you move, for example, from schematic to design development without having actually had the owner sign off on that. That can be fairly wasteful if the owner decides to come back and change something, what you're relying on is the owner's approval of the completion of the prior phase to be able to plan your resources accordingly. Because if you're going back and forth, that could mean that your project is no longer profitable for you. So generally speaking, during the first phase, it's the project definition and preliminary evaluation phase. The owner's objectives and priorities must be defined within the project environment. And the idea is that you have an early meeting of the minds so that the project requirements are actually defined and well settled. For larger projects, as we discussed, the design professional should really use a project summary report to make sure that both parties are on the same page. Once you've defined the project, then there's a study and report phase as envisioned by the EJCDC, or the schematic design phase as envisioned by the AIA. And really, this is to establish a uniform framework consistent with contract requirements that both parties can agree to. You're documenting all your assumptions and contingencies, and your deliverables at the end of this phase should be reviewed in accordance with quality program requirements that you may have. And you should also make sure that the owner has reviewed and agrees to what your proposed design solution is before you move on. The next phase, again, generally speaking, is your preliminary design or design development phase. And at this point, this is where you actually get into the meat of your solution. You're defining all the major systems, materials, construction details, dimensions, and relationships. You should be thinking about the cost consequences of your design decisions or proposed alternatives, and check and verify that these indeed still work. So at the end of design development or preliminary design, there should be a uniform level of completeness between different components so that it's clear what the structural solution is, what the mechanical solutions are, and so on, and that they work well together. Once the owner signs off on that, you're now in your final design or construction document phase, directed towards completed drawings and specs. And this should allow, at the end of this phase, to the builder or the contractor to price the construction solution. And the deliverables, of course, include final drawings and specs, procurement documents, bidding documents, conditions of the contract, and what your projected costs are oftentimes for the construction. Of course, that is going to often hit reality when the contractor provides a construction bid. So that really is how risk management in the planning and design phase works. The idea is that you are actively planning the project with your client and making sure that there's a meeting of the minds and it's documented and it's systematic, so that you, as a design professional, have a document on which you can rely, base your services, price your services, and make sure that both you and the owner are on the same page. So I don't think I see any questions, but if you have any questions, please feel free to email me. But that essentially brings us to the end of our program. For more information, we urge you to visit our website. Here's a look at our new website. If you've not already established an account, you should do so. Once you register, you can view claim studies, practice management information, contract language and commentary, and also our past webinars, and much, much more.